move on to the second question with yourself, Nick. This one is regarding, obviously, the early lease cancellation, and it goes as follows. We have tenants, so I believe it's also another agent. We have tenants wanting to give notice for end of October 2024. However, they have agreed to renew for a further 12 months, which will end in March now 2025. They've also paid the rental increase accordingly upon accepting the renewal. However, they have not yet returned the signed lease agreement. Does the tenant then, Nick, still remain reliable for the early cancellation if they have not signed the lease yet?
Perfect. So, first thing we need to just remind ourselves of is the requirement for lease agreements to be signed within South African law. The rule is always that you do not need to have a signed written document in order for a valid lease to come into place between the parties. Okay. Although we obviously encourage it, it's not a requirement that a lease has to be signed within our law. Okay. And so what you do when you have a circumstance where there isn't a written document that has been signed between the parties, you determine whether there is in fact a lease agreement by looking at the conduct of the parties and the circumstances. And the writer in this particular case has given us some great information about what has happened between the parties. So there's been a renewal, there's been an increase in terms of the agreed renewal, and the tenant has been paying since March. Okay, so we're a couple of months already down the line. They've been paying this increased renewal. And so this conduct does demonstrate to us that there is, in fact, the renewal has taken place and the parties are in agreement on those renewal terms. Okay, that is renewal terms for a period of 12 months. So that's out of the way. The fact that this hasn't been returned to the landlord in a written document is neither here nor there. It doesn't matter. The terms seem to me to be agreed upon and set between the parties. Now, that being said, this is a fixed term renewal that they have, okay, from March of this year to March of next year. And because it's a fixed term period, okay, we have to consider Section 14 of the Consumer Protection Act. So Section 14 of the Consumer Protection Act is going to allow this tenant in the circumstances to terminate the agreement earlier. What we don't have is information whether the tenant is using a particular clause of this lease agreement, but for the purposes of this question, I'm going to assume that there isn't such a clause and they're using Section 14. Okay, so the tenant, because it's a fixed term agreement, they would be allowed to terminate the agreement early, okay, by giving 20 business days notice. So as long as they do that, they can terminate, and they would be liable for a reasonable cancellation penalty if they are doing that. Okay, so to answer the question plainly, yes, they are still liable for a reasonable cancellation penalty. It's probably going to be, the tenants has gone through a substantial portion already, seeing as we're in October of that renewal period as it is. So you do have to take into account the relevant facts and circumstances to determine what's reasonable. But would they be liable for penalty of some kind? Yes, absolutely.
Right. Thank you very much. Then Nick, and then we've got